Good evening, everyone. Welcome to Constitution Day. We are very fortunate to have a wonderful speaker with us this evening who is also with us at noon today. His name is Professor Adam Winkler. He comes to us from UCLA Law School. Before I tell you more about Professor Winkler, a couple of housekeeping things. First, as I mentioned to those of you who were here earlier, we have the UIC bookstore here, and they're selling two of Professor Winkler's books, but also our brand new UIC John Marshall t-shirts if you would like those. Second, the caterer is running late. So the plan is going to be when the caterer gets here, we're going to take a little bit of a 5-minute time out and line up and let people get food, and we will recommence. And I thank Professor Winkler for understanding the situation with that. Professor Winkler is a specialist in American constitutional law, in the Supreme Court, and in gun policy, and he's going to be speaking with us tonight about gun policy. He has written 2 books recently, one, We the Corporations, that's what he spoke about at noon. That was a National Book Award finalist. It also won the Scribes Award, and most of you know that we're the national headquarters here at John Marshall for Scribes. He wrote a book a few years ago related to this topic called Gunfight, The Battle Over the Right to Bear Arms. And I love what he said in his bio. It didn't win any awards, but it was the answer on Jeopardy. So, gotta like that. In addition to his scholarly books and articles, he publishes materials in the New York Times, the LA Times, the Washington Post. His work has been cited by the U.S. Supreme Court. He's been on Adam Ruins Everything and the podcast Factually, so he gets all around with his publications. He earned his Bachelor's of Foreign Service from Georgetown. He earned his JD from New York University. He also holds a master's degree in political science from UCLA. After law school, he clerked for the Ninth Circuit and then worked for the LA branch of a well-known Chicago firm, Cat & Mushin, where, among other things, he was part of a defense team that represented Michael Jackson that he said drove him back to academia. Please join me in welcoming Professor Adam Winkler.
Thank you. We're going to do away with that image because it was a cover of my book that we talked about at lunch, and we're not talking about that. You know, they say you should start your talks with a joke. How about just awkward silence for a few minutes? Let's have a moment of awkward silence today. Well, thank you all very much, and thank you for your patience. Thank you to the Dean for inviting me here today. It's really been an honor. I've had a wonderful day here at the new University of Illinois, Chicago Law School. It seems like this is a really promising new beginning, and I'm glad to be the first official outside speaker, apparently. So I feel very honored. I wish to suggest today that the Second Amendment is at a crossroads. That the Second Amendment is one of our oldest rights, of course, added to the Constitution as part of the original Bill of Rights in the founding era. And the text of that provision provides that, quote, a well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. It's almost as if Madison, the author of this provision, had just discovered this wonderful new thing, the comma, and wanted to put it in there as many times as possible. And the sentence really doesn't make a lot of sense, and as a result, it's confused generations of Americans with different views about the Second Amendment, and a real question about whether it even protects an individual right to have guns for personal protection. In 2008, the Supreme Court provided clarity. One of the surprising things about the Second Amendment is that the Supreme Court didn't step in to clarify whether it was an individual right or not until 2008 in the case District of Columbia versus Heller, which involved a ban on the possession of handguns in Washington, D.C. And the court struck down that law and said that it was clear that the Second Amendment protected an individual right to have firearms, at least in the home, for personal protection. But the Heller case really left much of the Second Amendment's scope opaque and unclear. The court didn't identify a standard of review, for instance, that would apply to future challenges to gun laws. And the court didn't make clear whether the right extended beyond handguns in any clear way, or extended outside of the home in any clear way. There's some language in there in the opinion, but nonetheless, it has fueled plenty of controversy and confusion. Meanwhile, since the Heller case, the gun debate has heated up considerably, fueled by mass shootings and in places, unfortunately, like Chicago, a seeming never-ending stream of gun violence that takes nationwide about 35,000 lives a year, most of them suicide, but takes a large number of lives every year. Those who are following the presidential campaign have seen that the Democratic presidential contenders are falling over themselves, if you will, to find a more aggressive proposal for gun control, to have new and vibrant federal laws regulating guns, from universal background checks to bans on military-style rifles and high-capacity magazines. Those things have been talked about for a while. But today we're seeing major presidential candidates talk about mandatory gun buybacks, actual confiscation of certain firearms, and talking about a national registration system. Meanwhile, while politics seems to be moving in a direction for more, in favor of more regulation, and presidential candidates in the Democratic Party especially taking a very strong stand in favor of new and vigorous gun control laws, the Supreme Court, meanwhile, has 2 new justices and seems potentially poised to go the other way from the political momentum. President Trump has appointed Justices Neil Gorsuch and Brett Kavanaugh to the Supreme Court, and both of them are likely to have strong pro-gun views. Neil Gorsuch's record is a little bit opaque, but Brett Kavanaugh has, as a lower court judge, ruled in important Second Amendment cases, and he's likely to be an influential voice in how the court decides future Second Amendment controversies. And indeed, after 2008, the Supreme Court stayed out of the Second Amendment debate for the most part, with a couple of minor rulings, but for the most part has really allowed the lower courts to handle the Second Amendment controversies that have developed. But that seems about to change. Once Brett Kavanaugh came to the Supreme Court, the court took its first major Second Amendment case in almost a decade. A case is scheduled to be argued this fall at the Supreme Court, and a decision may come down in the spring or early summer of next year. And so while we have the gun control movement moving towards more regulation and gaining in political steam, we have a Supreme Court that seems more likely to strengthen and invigorate judicial protection of the right to keep and bear arms. And this is why I say the Second Amendment is at this crossroads. And I wish to suggest that at this crossroads point, that history and the history of gun control and gun rights is likely to play an important role in shaping the future of the Second Amendment. Now, history in the context of guns and gun regulation is often pretty surprising. When we think, for instance, about the basis for an individual right's interpretation of the Second Amendment, one might think that the best arguments come from originalism. Indeed, if you read the Heller case, which was written by Justice Antonin Scalia, maybe the most, who was the most high-profile proponent of originalism as a theory of constitutional interpretation, the idea that we're going to look to the original understanding of these words when they were adopted at the time of the framing. Originalism is what Justice Scalia was known for, and many people said that the Heller case was a triumph of originalism, in that the court emphasized the founding era history in its opinion, and emphasized the importance of history in shaping gun rights. But interestingly enough, I think when we look at the original understanding of the Second Amendment, I think that Justice Scalia didn't have the strongest argument. That originalism does not provide us the strongest argument for an individual right to bear arms. And surprisingly, I think that actually there's a much better case to be made on the basis of a living constitution, a constitution that has evolved from the founding era. Now, why would I say that? Well, one, I think there's a pretty weak case for originalism, and that Justice Scalia's opinion makes some of these things clear. One thing that when you go back and look at the founding era history, one thing that it becomes pretty clear right away, is that the focus of the founders was on militias and the right to bear arms in the context of militias. They did not talk about having guns for personal protection against criminals in your home, the right that Heller said was at the core of the Second Amendment. In fact, you can look through the founding era history and the literature of that period, and you find almost no conversations of guns being used as for personal protection. In part, this was because at the time, go back to the late 1780s, guns were not particularly useful for personal protection against a criminal. You couldn't store a gun loaded. It was a safety hazard. The gunpowder used at the time was highly explosive, and cities and states had regulations on the storage of gunpowder because it was something that people might commonly own, but it was something that was highly destructive and flammable. And so if you wanted, if a criminal was coming through your window back in the founding era and you wanted to defend yourself with a gun, you'd have to tell the criminal, can you wait a minute or two because I've got to load my firearm? And it was a time-consuming thing to do. Someone who was trained at it could probably do it in 45 seconds or so. Someone who wasn't that well trained, it would obviously take much longer time. But even 45 seconds when someone's coming into your home to threaten you means you're probably not going to use that firearm, especially because you're only going to get one shot off, right? You're rather going to take a club or something like that to defend yourself. And so we don't see any discussion of guns as a weapon of personal protection in the home in the founding era. Well, how is the right to keep and bear arms talked about in the founding era? Well, in recent years, we've seen the development of these databases, corpus linguistics databases that capture hundreds of thousands of sermons, pamphlets, letters, newspaper articles, books, and anything they can find with text from certain areas, certain periods in American history. And if you look at these databases for how was the language bear arms used back in the founding era, there was one study, Professor Dennis Barron examined this in a number of different databases. He found over 1,500 references to bear arms in the literature of that period. What he found is that more than 95% of those references were in the context of military service, suggesting that at least as the terms bear arms was commonly used in the founding era, it was used to signify military purposes, something that kind of resonates with the text of the amendment itself, which refers to a well-regulated militia being necessary to the security of a free state. So the corpus linguistics evidence is quite strong. Some originalists argue, and Scalia suggested this in his opinion in the Heller case, that nonetheless the Second Amendment was designed to protect a notion of self-defense, even in the context of a militia. How did you defend yourself through a militia? Well, the role of the militia was to defend the people from tyranny or from outside forces that might try to do harm, and that this is a notion of sort of national self-defense. I think that's a plausible understanding of the Second Amendment, but it seems to me at least a pretty big leap to go from defense of the nation to defense of a person in their home against a criminal rather than defense of a nation. Those are both some kind of self-defense, but they seem to be pretty big differences between the two. But that doesn't mean, and you shouldn't take me to be suggesting that I don't believe the Second Amendment protects an individual right to bear arms. I think that's the best interpretation of the Second Amendment, that it protects an individual right, but not because of originalism, but more because of a living Constitution, that we understand the Constitution today in light of the values that Americans have brought to bear over the years, the way history and tradition has shaped an underlying right. And I think in those terms, living constitutionalism provides a better basis for understanding the individual right to bear arms, at least that core concept that the Heller case said was embedded in the Second Amendment, the right to have a firearm in your home for personal protection. Because while the militia idea behind the Second Amendment was important to the founders, it quickly lost importance in American life and in American law in the early 1800s. Indeed, that by the mid-1820s, the idea of the militia being a key form of military service had already withered on the vine. And what we saw instead emerge in place of a militia-based understanding of the Second Amendment was the emergence of an increasingly powerful individual rights view of the right to bear arms. This grew first not out of the Second Amendment, but in state constitutional law. You know, if you read all the literature or you follow public debates about gun policy, you might be tempted to believe that the Second Amendment is the only constitutional provision that relates to personal gun ownership. And that may be right with regards to the federal Constitution, but we shouldn't ignore the fact that there are 50 state constitutions. Every state in the Union has its own state constitution. And one of the things that might surprise you is that about 42 of those states, of the 50 states, have provisions in their state constitutions for a right to keep and bear arms. And these provisions, some of which date back to the founding era, some of which have been adopted in recent years, most of them were adopted when a large number of states joined the Union in the late 1800s, and it was a standard part of their ordinary constitution to have a right to keep and bear arms. Well, if the Second Amendment is about preserving state militia service, as against federal tyranny perhaps, or the tyranny of outsiders, it would be hard to understand why you'd need such a right to keep and bear arms in the context of militia service and in state-level constitutions, because a state-level constitution can't stop federal tyranny by any stretch. And indeed, these constitutional provisions, although the Second Amendment wasn't authoritatively interpreted until 2008, there's been over 100 years of state constitutional law jurisprudence on the right to bear arms, not under the Second Amendment, but under state constitutional provisions, recognizing a right of the individual to keep and bear arms. And since the 1820s, we've seen a consistent, not exclusive, but a consistent trend line in these state constitutional law cases, recognizing an individual right to bear arms under state constitutional law. Now, why was this? Well, what happened in the 1820s and 1830s is guns sort of started to change. I mentioned that the militia became less important for how people organized or thought about national defense. At the same time, technology of guns changed. And we had the advent of the six-shooter, for instance, and the advent of ammunition that could be preloaded and then easily inserted into the firearm. Well, one of the things that the six-shooter and this new technology did was make self-defense with a firearm against that criminal coming into your home, that core idea that Heller identified, an actual possibility. It became something that people did start to envision guns as useful for. And indeed, that as we go through American history, that view of the right to bear arms, that it protects an individual and an individual's effort to protect themselves against criminals, has really taken center stage. Like most principles that emerge out of living constitutionalism, they wouldn't be worth their salt if it's just people making stuff up, right? When we think about the civil rights movement and how it changed the Constitution and our understanding of the Constitution, or the women's rights movement and how it changed our understanding of the Constitution, part of that process is a process of social movements, that we recognize that social movements can organize and can fight for a new reading of the Constitution. And that social movements can be a successful way of mobilizing the populace to support a particular understanding of the Constitution. It's hard to imagine. When I went to law school in the early 1990s, it was really hard to imagine that we'd have marriage equality for LGBTQ people under American law. Well, what has changed? Well, the text of the Constitution didn't change. What changed is we had a social movement in this country that changed how we understood the principles of equal protection, and it taught many people and showed many people that you couldn't still have a promise of equal protection while you're treating other people as second-class citizens on the basis of their sexual orientation or gender identity. And the truth of the matter is America's had a very successful social movement in favor of individual gun rights. The NRA is not just a political powerhouse organization. The NRA is the mouthpiece, if you will, of a social movement that's had a profound effect on American law over the last 40 or 50 years. One way we can see the effect of that social movement is looking at laws, for instance, on the carry of weapons outside your home. That beginning in the 1980s, the NRA and pro-gun voters pushed for states to make it easier for people to carry guns on the streets. And since the 1980s, 40 states have changed their laws to make it easier for people to carry guns on the streets today. That's the result of a social movement of people who really feel very passionate about this issue, and they're fighting for that issue in electoral politics. Indeed, think about it. Heller was decided in 2008. And although Chicago's own, the late Justice Stevens, called for the Second Amendment to be repealed, one has to ask whether that would really change much about gun rights in America. It was only 2008 that the Heller case was decided. I wish to suggest that the forces of pro-gun, anti-regulation politics were extremely strong in American politics before 2008. They didn't need the Second Amendment to become a political powerhouse. And indeed, they've changed the laws, for instance, in 40 states on the right to carry a gun outside of your home without needing a constitutional amendment to say it. That's the result of a powerful social movement. So what does this history, which has often surprised us, tell us about the compatibility of gun control and the right to bear arms? Well, one thing I remember when I was writing my book, Gunfight, I remember coming upon a photograph of the front entryway to the former headquarters of the NRA. And on the entryway, they had an etching, and the etching said, the right of the people to keep and bear arms shall not be infringed, right? A part of the Second Amendment. Well, conveniently missing from that quote was the first part of the Second Amendment, the part that talks about a well-regulated militia being necessary for the security of a free state. And I think that NRA, that quote, signifies, at least the view of some, that we can't have gun rights and gun control, that if we have gun rights, the gun control has no place. And the NRA tried to wipe it off the underlying amendment. Same can be said about many gun control proponents who are willing to look past or ignore the fact that there's this long history and tradition of individual gun rights in America and think that, well, if we want to have gun control, so we can't have a right to bear arms. The two ideas are fundamentally incompatible. And it's a strange idea in some ways that's shared by both sides in the gun debate, that you can't have both a right to bear arms and gun control. And I think that that's not right. I think that if we look through American history, we've long enjoyed gun rights, but we've also had a long history of gun regulation. The founders who wrote the Second Amendment had gun regulations. They banned certain people from possessing firearms, including loyalists, people who politically were committed to England rather than committed to the new country. We're not talking about people who were taking up arms and fighting against the revolution, right? It'd be perfectly understandable to disarm those people. We're just talking about people who had the political belief that historians estimate that probably about 40% of Americans shared at the time of the founding era, that the revolution was a mistake and that people's heads were going to roll because of it. So they banned, for instance, loyalists from possessing firearms. Boston, I mentioned that there were regulations of gunpowder. Well, regulations of gunpowder in places like Boston meant that you were not allowed by law to have a loaded gun in any building in the city of Boston. No home, no warehouse, no building whatsoever. Again, because it was a huge fire hazard. This is not desire to restrict gun violence necessarily, but it is an effort to regulate guns and how gun owners can access them in the name of public safety. The founders also had mandatory musters, where if you were a male between the age of 18 and 45, a free white male that is, you were expected to show up at mandatory musters as part of your militia service, and your guns would be registered on public rolls. That's one of the interesting things about the founders. They didn't have a lot of gun laws precisely like the ones we had, but one of the things they did have was an early form of gun registration to find out where the guns that were going to be useful for the military were. And indeed, during the Revolution, the founders confiscated firearms. They called it impressment. where if you weren't fighting in the militia, but they knew you had a gun that was useful for the militia, they would come and seize that gun, and it would be used for militia service. You were entitled and had a legal right to get that gun back at the end of the war, but government knew where that gun was and came to get it when public safety demanded it. Indeed, if we look throughout American history, we find similar episodes of gun rights balanced with gun regulation. We think about the Wild West, for instance, and no time or place more captures the heart of American gun culture than the Wild West. And that public image of the cowboy walking through town with a 6-shooter on each hip and ammunition strapped across the shoulder and maybe a rifle on their arm. It's amazing they could even get on a horse with all that metal. But we think of that as the image of the Wild West. But the truth is that historians who've gone back and looked carefully at the data find that our image is vastly exaggerated. That in frontier towns on the Wild West, while it's true that many people had guns when they were out on the Wild West, when you came into a frontier town, a place like Tombstone, Arizona, you had to check your guns with the local sheriff. You were not allowed to carry those guns through town. You'd get a little ticket like you get today when you check your coat at a restaurant in winter. I'm from Los Angeles. We don't actually do that, but I understand you might. So you get a little ticket. And indeed, when a famed gun haven like Dodge City, Kansas, right, was a place where when they organized that city government, the very first law they passed was a gun control measure, prohibiting the prohibiting the concealed carry of firearms in that town. So a couple years later, expanded to ban the open carrying of firearms too. And indeed, when we think about legendary Wild West moments, like the famous shootout at the OK Corral, been immortalized in so many movies and television shows, that's really a story about gun control. Tombstone had a law banning people from carrying weapons on the streets of Tombstone. And the outlaws involved in that case, in that incident, simply refused to follow the law. They were having a little feud with the local sheriffs, and they refused to follow that law. And the incident that ultimately led to the gunfight at the OK Corral was when the sheriffs came to take the guns away from the people who were carrying them illegally in the city of Tombstone. So, history also, when we look at not just norms and culture and activity, but we actually look at law, we can find a long history and tradition of balancing gun rights with gun control too. I mentioned all those state constitutional provisions and that there have been, over 100 years of cases on the right to keep and bear arms under state constitutional law, really more than 180 years, to be truthful, of cases arising under state constitutional provisions. There's hundreds of cases. And when you go back and look through the cases, what we find is that, in general, that the state courts upheld most forms of gun control. There are a couple cases that strike down this law or that law, but the states, despite all of their differences, almost all of them apply a reasonable regulation standard to gun laws that say that a gun law will survive so long as it is a reasonable regulation of guns and not a ban on the right to have them or a nullification of the underlying right to bear arms. When I did a study a couple years ago of all of the cases under the reasonable regulation standard that's used at the time was used by every state that had a right to bear arms provision. Some states have changed subsequently. But at that time, every state used it, and I could only find a grand total of 8 or 9 cases, depending on how you read them, that struck down a gun control law. Showing again that there's this long history and tradition of balancing gun rights with gun control. One of the surprising things that the history does provide, though, is a note of caution for when we adopt gun laws. Because gun laws over the course of American history were often used for racist purposes to keep African Americans or other vulnerable minorities from possessing firearms and fighting back for their rights. We look back through history, the founders, I said they banned certain people from possessing weapons. Well, among those who were banned were African Americans, even not only slaves, but also free African Americans at the time were also prohibited from possessing firearms. A law clearly founded in racism. That if we look in the 1920s, there were regulations of, some of the early regulations of carrying guns in the streets. Some people were motivated by a desire to keep those immigrants from Southern Europe who were known to be carrying guns from doing so. A real anti-immigrant fervor that was behind some of those gun laws. Even in the 1960s, when the federal government passed the Gun Control Act of 1968, there were commentators who said it wasn't going to do much to keep guns out of the hands of anyone, but maybe it wasn't really about controlling guns, but maybe because of the nature of those particular provisions in that law, about controlling black people with guns. The Gun Control Act had been preceded by race riots in cities like Detroit and Trenton that were devastating, and people often blamed the easy availability of guns for those riots. So it's not to say that we shouldn't have gun laws or that any gun law that's adopted is based in racism. I don't think that's the way to understand it at all. Like marriage laws, like property laws, many areas of American law have been infected by racism over the course of American history. And it's not that any law passed today will be racist, but it's at least a historical note of caution that causes us to at least think when we adopt a gun law, are we going to have racially disproportionate effects? One example where we might see this is California has banned the possession of high-capacity magazines. These are magazines that hold more than 10 rounds of ammunition, and it seems like a very good policy to get rid of ammunition magazines if they hold so many rounds, far more than anyone really needs for self-defense in the home. What Heller said was at the core of the Second Amendment. But there's no evidence that since the law was adopted that anyone in California has gotten rid of their high-capacity magazines. There's been none turned into police officers or police forces as far as we can tell. No big sale of them everywhere going on. So likelihood is that everyone in California still has their high-capacity magazines if they had them beforehand, even though possession is made illegal. So when is that law going to be enforced? Well, the government's not going to come to your home and ask to see your high-capacity magazine. That law is going to be enforced when someone's arrested on the street and has a gun on them that has a high-capacity magazine. And what's the effect of that is likely to be, based on the over-policing of minorities and vulnerable populations, that we're likely to see the majority of people, or at least a disproportionate percentage of people who are going to be charged and put in prison for some amount of time for having that high-capacity magazine, be racial minorities or vulnerable groups in society. Again, this is not to say that we shouldn't ban high-capacity magazines, but we should be cognizant of how these laws will work in practice and whether they're going to put their burden solely on the most vulnerable people in America. Now, the right to bear arms, I wish to suggest, is entering into an important new stage at this crossroads point, and I've suggested that history has some surprises in how it might affect us going forward. Heller said that there was an individual right to bear arms, but in many ways was a compromise. The court included in its opinion a statement that a paragraph that suggested that many forms of gun control remain constitutionally permissible. But many people have been dissatisfied with Heller's compromise. The lower courts in the wake of the Heller case have tended to uphold most forms of gun control. There have been over 1,000 federal court decisions on the constitutionality of a wide variety of gun control laws since the Heller case was decided in 2008. And a recent study found that about 95% of the time, the laws are being upheld. Courts are usually applying a form of intermediate scrutiny to gun rights cases in the absence of any direction from Heller about the appropriate standard of review. And this has led people to say that the Second Amendment is being treated as a second-class right. Now, you may scoff at my suggestion that we're entering a new stage in the gun debate in light of the fact that, as I hear from many people, you may share the belief that really nothing has changed in recent years. That Newtown was a horrific shooting back in 2012, and President Obama made a strong stand in favor of gun control, and nothing got adopted, and nothing has changed, and nothing has really changed since President Trump has been in office, and there's something, of course, to that truth. But I wish to suggest that a lot more has changed if we look elsewhere. and not just at the existence of new federal laws. There's been really the rise of a really new and vigorous gun safety reform movement that is manifested by new organizations like Everytown for Gun Safety. Gabrielle Giffords has started an important gun control and gun regulation organization. There's been a real influx of money to support pro-gun regulation candidates in American elections. Up until about 5 years ago, virtually all the money that was spent in American elections on the gun issue was being spent by those who oppose regulation, not by those who favor regulation. But we're seeing a more level playing field, where in the 2018, for instance, midterms, gun safety organizations spent more than the NRA did on election materials. And we've seen that has resulted, this new vigorous gun safety reform movement has led to new laws being adopted. Maybe not by Congress, but we've seen new laws passed in a wave of states, from California to Connecticut. And indeed, today in America, about 40% of Americans live in states that have tried to close the loopholes in federal law with vigorous new restrictions on guns. So nothing's changed in Congress, but most people are living in states where laws have been made, or not most people, but a good percentage of people are living in states where the gun laws have shifted and have been reformed. And I think there's a real clear indication when we look at the change in the Democratic Party's position on guns in recent years. As I mentioned earlier, that the presidential candidates are making gun regulation a really important, a centerpiece of their campaigns. This is vastly different from when, for instance, President Obama ran in 2008. When he ran his first election campaign, he believed, as many Democrats at the time believed, that talking about gun control on election day was a loser, that it was a bad idea, that it would cost you swing districts where the pro-gun vote tends to be pretty strong. And indeed, during the 2008 campaign, Obama rarely talked about gun control, and when he talked about it, he was always sure to talk about the importance of protecting Second Amendment rights. It really wasn't until 2012, after President Obama won re-election, and the horrific shooting in Newtown happened in early December after his re-election of that year, that he really made gun safety regulation an important part of his agenda. But now we see a big difference when you have candidates like Beto, who says, hell yes, we're coming to take your guns. Something that Democrats for many years have been very afraid to say, not only to say, but to even think would be a valuable or worthwhile policy. I think that really shows and suggests the change. But like I said at the beginning of the talk, we also have a new Supreme Court. The court stayed away from gun cases for many years, but the court seems to be ready to step back in. And history will likely play an important role, and I think in part because of Brett Kavanaugh and his view on guns. Brett Kavanaugh, when he was a judge on the D.C. Circuit, wrote a dissent in a case where the D.C. Circuit upheld a ban on military-style assault rifles. And he dissented in that case and said that the way to understand Second Amendment cases, the way to decide Second Amendment cases, is not by applying this intermediate scrutiny that the lower courts have tended to apply. It's by applying the lessons of history and tradition. And he said that's what we should look to figure out whether a gun law is constitutionally permissible or not. The question, though, with history and tradition analyses, though, as a guide for judges making these decisions, is what level of generality do we apply when we look back at history? Right? Is a ban on military-style rifles, does it have historical precedent? Well, it depends on how we frame the underlying precedents. I've suggested there's been a number of different kinds of gun laws that we've had over time, balancing gun rights with public safety. Is that the right level of generality? Okay, so then a ban on military-style rifles is part and parcel of a long history of efforts to regulate guns in the interest of public safety. It still preserves the core right of a right to have a firearm in your home for personal protection. You could ban military-style rifles and still people could still have as many handguns or other kinds of rifles as they wish. Kavanaugh, in his dissent in that District of Columbia case, said that the right history and tradition to look for bans on military-style rifles was, is there a history and tradition of total bans on semi-automatic weapons? Now, military-style rifles, for those of you who don't know the technology much, are considered semi-automatic. That doesn't mean that they're machine guns. If you want to shoot 2 rounds, you have to pull the trigger twice. Semi-automatic just refers to the mechanism that's used to load that next round and prepare it to be shot. And Kavanaugh says that, and military-style assault rifles are semi-automatics. And Kavanaugh says, well, there's no history of banning semi-automatic rifles. But one might challenge that as the appropriate level of generality. Indeed, the ban on military assault rifles is not a ban on all semi-automatics. Indeed, about half of the handguns that are sold in America today are semi-automatics because they have that same mechanism and technology for loading that next round of ammunition. And a ban on military-style rifles does not prohibit semi-automatic rifles. It allows you to have a semi-automatic rifle as long as it doesn't have other characteristics that put it in the category of a military-style rifle. So Kavanaugh says the right level of generality is there a history of bans on all semi-automatics? But one might wonder whether that's the right level of history to apply. Why not apply a more general level, a broader level of generality, to look at whether there's a history of efforts to balance public safety with gun regulation? I don't have the answer to this question, but it is to suggest that while history is going to play an important role, I think, in the Second Amendment going forward, there are important normative questions that still need to be asked. That sometimes when we look at history and tradition, we sometimes think that that is an objective or non-political way of going about solving or answering a question. But there are always normative choices to be made in terms of which history you're going to look at. Which history do you find persuasive? As Kavanaugh's dissent suggests, there are a lot of different ways you could go about that, and none of them are totally free of normative implications. We should see before long exactly what direction the Second Amendment takes now that it's at this crossroads. I mentioned earlier that the Supreme Court has taken its first major Second Amendment case in 10 years. It's a case out of New York City that challenges a New York City Police Department rule that restricted where you could take a gun. If you had a permit to have a gun, you could only take it to one of a number of listed places in the statute. But you couldn't take it anywhere else. And so this law was challenged by some gun owners who wanted to take their guns to gun ranges outside of the city of New York, which you weren't allowed to do under the rule, or to their homes in upstate New York, which again you weren't allowed to do under New York City's rule. And so this case really has the potential to be a blockbuster Second Amendment case with the new majority on the Supreme Court, and the possibility that the court will step in and make clear that Heller means much more than what the lower courts have suggested, either by adopting a higher standard of review for gun cases, or for saying that the right to bear arms does indeed extend outside of the home, something that the Supreme Court has yet to clarify. We may nonetheless have to wait at least a little bit longer, because as things work in the gun world, there are surprises and always another seeming twist. And with regards to the New York case, New York has just recently petitioned the court, sent a letter to the court, suggesting that the case is now moot, that the city police department has rescinded its rule, and then the state legislature has stepped in and passed a state law prohibiting any jurisdiction or government entity in the state of New York from adopting such a law in the future. So we have this odd situation where the Supreme Court has its first big Second Amendment case for years, but the underlying law, which was the only one of its kind in the whole country, has been now repealed, and the state has passed a law saying you cannot adopt this kind of rule ever again. Would a Supreme Court opinion on that issue be an advisory opinion? It will be odd to see what happens. There's even the possibility that New York will refuse to defend its own law because it's no longer its own law. But nonetheless, you should know that that this case was made, if it is mooted, it was done on purpose. That New York State lawmakers worked with gun safety advocates specifically to try to avoid the Supreme Court ruling on this issue. And so that's why the law was repealed and done in a way that makes it impossible for the city to reissue it. But if that was their indeed goal, as I think it was, it might not be that successful, their strategy. The court may still keep this case, but even if the court dings this case, as it should for being moot, there are about 4 or 5 cases that are already at the cert stage, raising other major and important Second Amendment issues. And so it seems that without doubt, the battle over the right to bear arms is coming to the Supreme Court before too long indeed. Thank you very much.